Welcome back to the video lecture on East Asian state leadership in international law. This time, we are going to discuss the very serious manner in Korean issues, which is the Dokdo. We are going to talk about Dokdo policy and discuss the very details of the issues. Let me first touch upon the core of the Dokdo issue. The core of the Dokdo issue arising between Korea and Japan is the territorial dispute. The territorial dispute requires a comprehensive outlook on various spheres such as history, geography, and bibliographies, and more. However, as to where the sovereignty lies is ultimately determined by the perception and perspective set out by the international law. In other words, it is important to keep in mind that the significance or admissibility of the evidence presented by the parties in proving the sovereignty of the disputed territory is determined by a third-party neutral arbitration agency or international court or tribunal in light of the general principles of the international law concerning the acquisition and loss of the territory. Therefore, it is required to approach the Dokdo issue from the perspective of the third-party neutral arbitration agency or international judiciary body. In November 22nd, the Japan had protested to the Korean government about National Police Agency Commissioner General, at the time is the Kim Chang-yong's visit to Dokdo, and later boycotted to joint press conference with the Korea-US Vice Foreign Minister's counterparts. The National Police Agency of Korea has stated the visits hold no diplomatic meaning but to encourage the Korean personnel serving in remote islands. However, the Japanese government claimed that Takeshima is the Japanese name of the Dokdo, is indisputably an inherent part of the territory of Japan in light of the historical facts and based on international law. Regarding proposal to visit Dokdo, the then presidential candidates of the Democratic Party, Lee Jae-myung, said, "I am also torn," adding, "It is good to show Japan and the international community that Dokdo is under effective control of Korea, but there are concerns about intensifying the disputes." In the past, Dokdo Oceans, a science station, which was planned as a comprehensive management measure for Dokdo, was built on land, but was moved to Sochong-cho in the West Sea in 2014 due to the concerns of the Japan's potential lawsuit claiming Korea's violation of the duty of the marine environment preservation. Dokdo is indeed our own territory, but a territory not free to exercise complete control. The public outrage over Japan's claim of Dokdo will require the government to take strong measures, and the government will spend a considerable budget to promote police and projects to strengthening the claimed sovereignty over Dokdo. However, the fact which should not be overlooked is that the legal significance or the status and claim of sovereignty over Dokdo is not strengthening and weakened by a mere installation of the large physical structures. Furthermore, the fact that the Republic of Korea Army and Navy Air Force, including the Marine Corps, are physically residing on the land of the Dokdo, nor the act of a presidential visit does not cause any change in the legal status in the claim of sovereignty over Dokdo. It is desirable that state actions are executed to minimum within the scope of maintaining the status quo. In this end, a Dokdo defense drill, so-called East Sea Territories Protection Training, which took place the last December of the 2022, as described the joint training by the military and the Coast Guard, was a very appropriate measure. As you know, that the Korea's official position on the sovereignty Dokdo states that Dokdo is Korean territory. This fact is irrefutable geographically and historically and according to international law, and no territorial dispute exists regarding Dokdo, and Dokdo is not a matter to be dealt with through the diplomatic negotiations and judicial settlement. If so, what meaning is attached to the claim of no territorial disputes in the unfolding dispute over Dokdo issues between Korea and Japan? How convincing is this proposition when the Dokdo issue is one such generally recognized as a major dispute amongst the third country's experts? For peaceful resolution of the dispute, Modern International imposed obligation to each party to the dispute to negotiate in good faith. However, the law does not oblige the parties to resolve the dispute at all costs. Thus, the claim that there is no territorial dispute is, put in other words, claiming there is an obligation to negotiate in good faith under international law. In order for the Korean government to withstand its claim of a non-existence of the territorial disputes, a consistent and intricate pan-government dispute management is needed within the framework of the modern international law. The encouragement to visit to Dokdo by the Korean National Police Agency Commissioner General is a valid exercise of the national public power as a means of the on-site inspection of the police personnel stationed in the far eastern border of the Korean territory, but rather regrettable gesture in light of the dispute management. Considering the rapid changes and developments of international law and jurisprudence relate to the issues of the sovereignty, the Coast Guard planning and marine environment protection and the government response to Dokdo issues in the future should also change. Let me looking at one of the example, the 2016 South China Sea arbitration case. The 2016 South China arbitration case between the Philippines and China rendered by the Permanent Court of Arbitration, which is often cited in recent rulings, has implications for the Dokdo issues. The first, the significant attention is being paid to the tribunal's interpretation on its power to exercise jurisdiction. In 2006, during the Korea-Japan's dispute over Japan's waterway exploration plan in Korea's exclusive economic zone nearing Dokdo, the Korean government has submitted a declaration to exclude compulsory dispute resolution procedures under the United Nations Convention on the Law of the Sea. This action has raised a legal defense that excludes the dispute related to maritime law and ocean law from compulsory procedures under the UNCLOS, maritime enforcement measure and military activities, and marine science research, and the fishing law enforcement activities and other actions by the United Nations Security Council. However, the recent South China Sea arbitration trial began to raise the limitation of the UNCLOS claim to exclude the compulsory jurisdiction. For instance, the scope of the arbitral tribunal's decision was bound to determining the legal status of the individual topography, but in effect is sovereignty of the state and the maritime boundary. In other words, the filing a lawsuit related to issues surrounding Dokdo has become conceivable at any time and by any means. The second, the heavy focus on the environment aspect in the arbitral tribunal's decision. The tribunal noted Chinese artificial island building activities causing devastating damage to the marine environment. It viewed China as violates its obligation to take necessary steps to protect and preserve the marine habitats and vulnerable and rare endangered species threatened by the depletion or extinction under the UNCLOS. Furthermore, the tribunal also found that China violates its obligation to conduct environmental impact assessments and report the result to the authorized international organizations. Applying the decision in comparison to Dokdo, any construction activities in Dokdo and near its waters can lead the lawsuit at any time from anywhere as possible violation of the protecting marine environment. The Dokdo issue, therefore, require a comprehensive approach within the bounds of the nation's ocean management system based on the perception of international law. This perspective should also be reflected in the diplomatic and domestic countermeasures and the legislative process as well. If the said island is an inhabited island, it should be approached in a balanced manner by considering all three features, such as the territory of the island itself and waters and the residents inhabiting in the area. In the case of Dokdo, the territory and its waters are key factors. Essentially, Ulleungdo and Dokdo should be managed as one unit. The meaning of water gains a significance beyond the legally defined area to enjoy. It functions as an economic, a security, and living territory. Assuming the status of the demarcation taking place in the waters of the Dokdo near the undefined waters in the future, the decision-making policy should be shifted to direction to focus on the management and protection of the given waters along with the territory. Dokdo is one of the fundamental issues in Korea-Japan's relations for Korea and the portrayal of the states of the Japan to Koreans. The text of then President, former President Roh Moo-hyun, in a special message on Korea-Japan relations in 2016, read as follows. Dokdo was the first territory of Korea to be seized in the course of the Japan's usurpation of the Korean Peninsula. Japan's present claim to Dokdo is tantamount to maintaining a right to what it had once occupied during an imperialist war and aggression, and what is worse to reasserting colonial territorial rights in bygone years. This is an act of the negating the complete liberation and independence of Korea. For Koreans, Dokdo is a symbol of the complete recovery of sovereignty. The measure of economic stake or cultural exchange will help break down this barrier. Such statements still yet reflected Dokdo as a territory and remain as so. Today, it has reached the point for Dokdo policy to expand and develop into embracing Dokdo with ocean areas. Moreover, such policy should be operated in the calm and firm manner of diplomacy, with emphasis on the calm rather than firm approach in the broad scheme. Thank you very much for your attention.